Hello, everyone, and welcome to the first episode of Writ and Talk by the Center for Comparative Constitutional and Administrative Law from National Law University, Jodhpur. I am delighted to have all of you here for the first episode. With the help of this podcast, the Center aims to bring clarity and to build discussion when it comes to writing on constitutional law and administrative law. We aim to interview authors of academic papers on varied subject matters that the journal deals with. We seek to go in depth with the theme of their piece, the arguments that they raise in their article, the journey of discovering the topic, the methods and techniques used by them to derive their arguments, and so on. This initiative is an attempt to increase dialogue, discussion, and engagement with legal writing. In this episode, Assistant Professor of Constitutional Law at National Law University, Jodhpur, Ms. Sayantani Bagchi hosts Ms. Jayana Bedi and Mr. Prashant Narang, both members of the Research and Training Program at Center for Civil Society. Both the speakers will be discussing their article titled Assessing State School Education Laws on Administrative Safeguards, which is published in Volume 6, Issue 2 of Comparative Constitutional Law and Administrative Law Journal, the flagship journal of the Center. You may find the transcript of this podcast and relevant article on our website mentioned in the description. Over to you, Ms. Bagchi.
Thank you, Saurav, for the introduction. We are looking forward to hearing the authors talk about their insights, their experiences, and all that went into the writing of this paper. I'm sure it will be an enriching learning experience for all of us here. So the first question that I have is, in your article, you have talked about the ill effects that unfettered discretion of the executive might have on the education system in terms of introducing unreasonable criteria and such for schools. So, in a more practical sense, in your study, how and to what extent have you seen this misuse come to life in schools, especially those that do not have the means to challenge these wrongs?
Last year, we conducted a survey of 950 schools across 5 states in India, and some of the budget private school owners shared with us about their struggles. One of them said that the procedure is so draining and long drawn out that a lot of children miss out on going to school at all because of the time it takes to set one up in the first place. Another school owner said, "We can't work without bribing. It happens every time without fail. I spent about 23 lakhs on just bribing this year." Then another one said, and I quote, "I cannot explain the extent of corruption here. It feels like most of these government officials do not have salaries and they have to take bribes for survival. We are helpless." End quote. So these are some of the examples of what school owners go through. We conducted another study on how difficult it is to open a school in Delhi. And as per the law, it should take 4 months to receive the essentiality certificate and the certificate of recognition. But there was one application pending for final approval even after 14 months. In another case, it was under review. The application was under review for 5 years. So, I mean, these cases show that, when we talk about ease of doing business for other sectors, but we have completely ignored ease of opening schools.
Right. Thank you. Thank you so much for your observations. And I think that's quite unfortunate, of course. So, from here again, if we are to ask you that, as far as we could make out through the reading of your paper, Karnataka has come the closest regarding the state rules, but it too has its own flaws. So, how do you think the Karnataka legislature has actively worked for the betterment of the education system, and how can it undo its remaining and existing flaws? Because that becomes ultimately the objective.
So you are right. There are some good features in Karnataka laws, but there are also flaws. China, do you want to talk about it?
Yeah, sure. So actually, I mean, broadly speaking, we couldn't identify any state that we think, is ideal. In most cases, the laws are a mixed bag. They get some things right, but on other aspects, they fare very poorly. So, for instance, I can share some things that Karnataka has done well. and exceptionally well at that, meaning some of the provisions it has are actually not seen in other laws at all. So, for instance, the Karnataka Education Act 1983, it's a fairly old law, but one thing it does that most other laws, not just state school education laws, but otherwise also, an important safeguard that they miss adding is a pre-decisional hearing or an opportunity to be heard before your application is rejected. So even before you can refuse to grant an approval, you get an opportunity to be heard. Now that is something that is rare in most Indian laws, but it's under Section 96 of the Karnataka Education Act 1983. This is a mandate that executive has to give an opportunity to be heard to the party that has submitted an application for recognition, which in this case would be a school that has submitted an application to get recognized. So even before you pass an order to reject their application, you have to hear them out. But and it also mandates, it's also one of the very few states that mandates a reasoned order in case any kind of approval is denied, not just recognition but also upgradation of schools. So when I say reasoned order, I mean my sense is that most people, most of the audience for this podcast would be aware of the technical terms, but just for the benefit of the listeners, reasoned order would be basically not just a written order, but a written order that records reasons for rejection. So, some states only mandate that the executive writes out its order. The other laws sort of mandate that the executive gives reason, but does not also mandate that the reasons be written. So, Karnataka is one of the few laws which mandates both, that you need to write down the reasons. Then another important sort of safeguard it introduces is an independent appeal mechanism. So Karnataka Education Act, again the same law, it requires that the state government forms an independent education appellate tribunal to adjudicate any kind of appeals. So if a school is disgruntled or disagrees with an order of the director, then they can appeal that order and take their appeal to the tribunal. Then, similarly, another interesting provision in Karnataka Secondary Education Examination Board Act of 1966 is that it requires all the orders passed under that law to be laid before the parliament soon after it is sort of notified. So this is again something rare. But having said that, Karnataka also has its own issues. So, for instance, a big one is that it allows the executive to give retrospective effect to rules, which can really harm school owners, because then you're basically not operating in a very predictable regulatory environment, right? So that is a big issue. Similarly, it has some excessive prohibitions. So, for instance, school teachers cannot give private tuition to any individual. So, it's not just that you can't give private tuition to students in your school, but basically any individual. So, it in some way prevents the individual from having another source of livelihood.
Okay, thank you so much, Ms. Bedi, for this clarification, because Karnataka, as you have pointed out, has served as a model, and of course, it has come the closest regarding the state rules. And you've also talked about the principles of natural justice. So, in continuation of that, we generally see that under several state rules, there's no provision for an appeal when a school has been denied recognition. And several states, they've formed their own mechanism by having an internal mechanism where senior officers of the education department against whom the appeal is filed hear the appeal. Now, how does this go against the principles of natural justice set out in the administrative law? And how has this been questioned in the past?
So, Ms. Bagchi, another thing that we find it important to mention here is across all states, there's one thing in common, which is that the department that runs government schools also regulates private schools. And so there is a structural flaw which goes against the principles of natural justice, that there's conflict of interest. And definitely what you mentioned is also about the appeal mechanism, that the appeal goes to the senior officers of the same department, and then they hear the appeal. So, around 17 laws allow for appeal against all approval related decisions of the government, and 12 laws allow an individual to appeal against all kind of enforcement action or measures. Now, the question about the independence appeal mechanism, we know that the key principle of natural justice is that no one must be a judge in their own case, right, to avoid bias and there shouldn't be any conflict. But only a few state laws mandate education tribunals. So, for instance, Gujarat, Jharkhand, Karnataka, their tribunals have a judicial officer who is not below the rank of a district judge. But in other cases, the appeal may go from a lower level official to a higher level official in the same department. So, for instance, under Maharashtra law, the director needs to appoint one or more administrators to manage the education institution taken over. An appeal against this administrator goes to the director. Now, Maharashtra law also mentions that the appeals against some decisions of Director of Education and the state government are explicitly denied. So, uh, as far as the independent appeal mechanism is concerned, it's very few laws that have it.
And what's worse is this last part, that in some cases, even after one level of appeal is allowed, laws sort of outright disallow further appeal of that decision. So, in some cases, like Prashant mentioned, the Maharashtra law, the decision of the director or the state government is supposed to be considered the final decision. One cannot appeal against it in to the court.
Okay, so that's pretty astonishing, because these principles of natural justice, probably these are all pervasive, and a blatant violation of this is more unfortunate, specifically given the concern before us. So this brings me to another important area. Like, I was particularly surprised to read the incarceration provisions under the education rules in several states. And while it brings to notice the futility of such a provision, since it would only result in penalizing an authority that has the resources to pay and remains unbothered by the penalty, it also questions the necessary recourse that needs to be introduced for punishing or penalizing those who breach the standard of school, I mean, the standard of education in schools. So, what are your views on this particular issue?
I think the entire, the mindset or the philosophy of regulation behind these provisions is quite outdated. When we talk about corporate laws, we are moving from criminal statutes to penalties, to civil penalties or fines. So there is a shift towards decriminalization, or at least doing away with imprisonment and jail terms. And we advocate for the same thing for the schools. That's one thing. And something which is different but also similar to this is the idea of incentives. So instead of having a carrot and stick approach, instead of saying that if you don't do this, you will be penalized. Now, penalty either in terms of jail or in terms of fines. But rather than this, penalty-based approach, why not incentivize good standards? So how not, why not create a system where schools strive towards excellence on their own rather than moving in that direction based on penalties and imprisonment. So all the laws across all states have this outdated philosophy or outdated regulatory architecture, and we envisage that the school education laws should rather be based on good incentives where there is win-win situation for all stakeholders. And one way to do that is to encourage more and more competition among schools, and not just among private schools, it could also be among private schools and government schools. One more thing that I would like to mention here, which was recently mentioned in the National Education Policy 2020, And national education policy has specifically talked about regulatory asymmetry between private schools and government schools. So if you look at Right to Education Act, Section 18 and 19 of Right to Education Act talks about closing down private schools. There are heavy penalties on private schools if they don't adhere to norms and standards given in Right to Education school. But there is no provision to apply recognition, the concept of recognition to government schools. Government schools are deemed recognized. And so there is no possibility of shutting down a government school or penalizing a government school if it doesn't adhere to same norms and standards. So I don't mean that the government schools should be shut down, but my question is, why should even private schools be shut down? And then, of course, the other question which NEP also raises is about, the emphasis on norms and standards. I mean, a school is about education; it's not so much about building and other facilities. But that's a separate story. Jaina, do you want to add something?
Sure, yeah. Just briefly, on this, I mean, the way we've looked at the imprisonment story in our paper is, we've spoken about how the proportionality test has four elements that, which is legitimacy, suitability, necessity, and proportionality, stricto sensu. So, some of the provisions introduced in our school education laws are clearly disproportionate, meaning the penalty is not proportionate with the breach, with the violation or the breach that is being penalized. So, for instance, I mean, just to give an example, for instance, the Madhya Pradesh 1975 education law, it mentions that the breach of any rule which is formulated under this act could attract imprisonment of up to 6 months, which is vast, right? Because there are a number of things that the rule could speak about. And this basically gives the government power to imprison a school owner or someone from the school management for a breach of any such rule. And the same is true for Andhra Pradesh Education Act. And so such disproportionate costs, they not just, impinge on the life and liberty of individuals, which itself is salient and crucial, but I mean, something that you also mentioned in your question, which is that it imposes lots of costs. So Richard Epstein, he has this book, Simple Rules for a Complex World, and he actually gives this nice framework to look at costs. So he talks about three kinds of costs. One is the costs that the regulated entity has to incur. So in this case, the school management in trying to fight such a claim. The second is the enforcement cost. So the cost that the government has to incur in running, in identifying this breach and also then penalizing the breach. And the third is also the error cost, the cost that you have to incur when you penalize someone wrongly. So just that framework I wanted to mention.
So,
And
which
maybe
means that there would be huge deterrence. I mean, why would somebody then enter into
exactly,
the school education market if
exactly.
the deterrence is so high and if there is so much of risk? So, actually, last week when I went to Guwahati and met some private school owners, they told me that how they feel anxious right from 6 o'clock in the morning to 3 p.m. in the afternoon when the kids are picked up by the bus and then finally dropped at home by the bus. And because there is so much of stringent penalties associated with even the bus transport,
Transport.
there are so many rules associated with now with the bus transport that it becomes very difficult to comply with all of those, and making
Absolutely.
the school owners anxious. Yeah.
Just as a funny aside, this budget private school owner said that you can do a health checkup study, and I guarantee that most budget private school owners will have heart issues,
Or hypertension.
insomnia, hypertension, high blood pressure, things like that. Yeah.
So yeah.
Yeah.
Okay, thank you, Mr. Narang and Ms. Bedi. I think all that you have talked about, I think that's an outcome of a very very detailed and elaborate research work, of course, because a lot of brainstorming and hard work has gone into the process of writing this, and most importantly, the empirical work that you have undertaken to actually write this paper, to even conceptualize it. So keeping in mind that the article is based on empirical data collected by the Center for Civil Society, I'm just curious to know that what role do you think similar civil society organizations working towards the accessibility of education would play in ameliorating the situation on the ground in terms of the absence of the four safeguards that you just talked about, and the problems which stem from it, particularly the abuse of power in the forms of corruption and rent control.
Um, I think there is a need to link what is happening on ground to absence of these safeguards. And for the benefit of listeners, let me again reiterate those four safeguards. Number one is procedural safeguards, including due process and principles of natural justice. Number two is guidance provided by the law for the quasi judicial functions of the executive. Number three, proportionality. And number four, checks that the law places on the rule making powers of the executive. So, while government agencies such as Niti Aayog has come up with an index which is called the School Education Quality Index, FICCI came up with a model school code. Center for Civil Society, in association with other NGOs, came up with another draft school code. Um, but we need to be very, very clear. I mean, people look at these laws from different aspects. Somebody might look at it from an economic analysis point of view. Somebody may look at it, let's say, from consultation point of view. And NEP was a good example, by the way, of good example of participatory policy making, because the government indeed put it in public domain and did stakeholder consultation on a large scale. Now, interestingly, while Center for Civil Society has been working in the field of education for past 25 years, for last couple of years, we are also working on this idea of quality of laws or quality of regulations. And so what we realized, and by the way, we are not the only one in the world that has been thinking about quality of laws. There are other institutions such as the Mercator Center in the US that had talked about quality of laws for an empirical or a quantitative methodology. And we partnered with them to also look at Indian laws from a quantitative side. But again, that's a separate story. I'll come back to that maybe later. So, looking at quality of laws, we realize that there are three components when we talk about quality of laws. One is the representation safeguards, meaning that to what extent participation or let's say consultation has been done, and there can be some questions framed around the consultation aspect. And the other aspect is the resource allocation safeguards. And world over there are many agencies and many institutions such as the World Bank or OECD have talked about impact assessment. Jayana just now talked about Richard Epstein. How we think in terms of cost and incentives when we talk about economic analysis. So there are also some variants how you can think about the economic analysis of law. So these are usually these two buckets, consultation, participation, and the other one is economic analysis. So while we have talked about resource allocation and representation safeguards, our addition to this body of work was also discretion analysis or right safeguards. And this we borrowed from the administrative law. And so what we did was basically we applied, uh, this discretion analysis to these education laws. And our nudge or our message to other NGOs working in the field of education is that while cost benefit analysis is important, while participation and consultation is important, right safeguards are also equally important, because absence of these safeguards indeed lead to a lot of corruption, lead to harassment, and there can be better models of regulation without taking away or without impinging on school owners' rights. Jayana, do you want to add something?
No, I think Prashant has broadly covered. Just closing the loop on this question. Just I think, as Prashant mentioned, CCS has been working closely with FICCI and Niti Aayog, or has worked rather in the past to build a school code. And our attempt there has been to build a code in a manner that checks against abuse of power. So it incorporates these four safeguards, and because it's a code, and it's a state school code, it's basically a document that can be then used by pretty much any state across India. Apart from that, I mean, there are not many think tanks that work on education governance, really. um, so I guess one role that civil society organizations can play is just talk more frequently about these issues of misuse of executive power and the burden it imposes on private schools, because for some reason, this discourse in India is such that private schools tend to be villainized. So just it's important that civil society organizations also recognize the important role that they play in educating the children of this country, and the burdens that they unfortunately have to face. So yeah.
Okay. Uh, Going from a very important thing that Mr. Narang has highlighted, and that is the presence of economic analysis. So, I just have a question here. So, do you believe that this kind of economic analysis is missing from the body of public policy literature currently available? And if you think so, how important do you think that it is? I mean, in the current, in the given context in India, how far is it important? And further, if you have faced any material limitations while conducting such research, if you could further illuminate us on this.
So, if you look at, let's say, law commission reports, there have been close to 300 law commission reports,
277.
around 277 law commission reports. And particularly the law commission reports in, let's say, 50s, 60s, 70s, 80s. So, in the first 40, 50 years, most of those reports were based on opinions, if I may say so. And it seems like that we are reading some opinion editorials, and then gradually we see that they would refer to some literature, articles and journal papers, but they don't talk about numbers as much. And economic analysis, I think very few law commission reports would talk about economic analysis. And the important function, the important role that these commission reports play. And this is just an example. I'm not kind of criticizing Law Commission or its reports, but I'm just giving an example of how policy making has been done in our country. And by the way, the recent reports, especially, there were reports that were done, let's say, in 2015 by Justice A.P. Shah in partnership with NLU Delhi. Those were some of the best the law commission reports, because they talk about how to define a particular term and then how to measure it. And so the methodology was scientific, and this is what we need to bring to our studies, and make them more scientific. Another example is the parliamentary debates in 2014 on the Narcotic Drugs and Psychotropic Substances Act. And that would show how members argued for harsh punishments by relying on opinions rather than data. Whether these punishments successfully deter drug users or traffickers. So often, something goes wrong, the immediate reaction in our country is to advocate for harsh punishments. We all know about Nirbhaya rape case. Instead of talking about police reforms, we talked about death penalty. So the country debated on death penalty rather than talking about police reforms. So, not to mean that qualitative research is not important. Yes, that's very important. Economic analysis is also very, very important, because that talks about incentives and costs. And then empirical research is also very important. Numbers are also very important. So it's not about a single method, but it's about mixed method. That all methods are important, and we need to see that we don't over rely on one method, and see then what else we need to find out, and then think about those methods or those aspects when we talk about policy making.
Thank you so much, Mr. Narang, for this wonderful, I mean, explanation of the work, the fantastic work that you've come up with. So I would have this last question of mine, and that is your collaborative effort at developing good governance indicators, in your opinion, presents a growing concern for good administrative practice in India. So, do you think that there is a need to concretize this shift towards legal quality management in the form of a standardized law, maybe? Or should the development of such good governance indicators be left to the private sector?
um, so I do think that we need to have an institution in place that can oversee the quality, or that can audit the quality of policies or laws. And yeah, law commission can be one such institution, but it needs a complete overhaul. Right?
Yeah, no, I agree with Prashant. I mean, there are different approaches to see. The first thing that needs to be done is, I mean, the term that you've used, good governance indicators. The first thing that we need to do is come up with these indicators and understand what principles guide these indicators. Once that's done, there are two, three approaches, different approaches that a country could adopt. So, for instance, in the United States of America, there is the Administrative Procedures Act, which codifies a lot of these safeguards, on how the executive is supposed to act. So it's not that every law must have it, but there is a law and administrative procedure that governs how the executive must operate. So it introduces all of these due process checks and principles of natural justice in that law itself. The other approach that we've been pushing for, which Prashant spoke about in detail in response to another question, so I wouldn't spend too much time there, which is the quality of laws toolkit that we've developed. So the idea is that all the key principles, after you've identified them, you take a checklist approach, where you make them translate those principles into um, a checklist, and then you basically apply that checklist to every law to see whether it meets the benchmark or not. So benchmarks in terms of representation, is the law publicly accessible, was the law made after due public consultation, things like that. Similarly, checks on legal safeguards, as Prashant mentioned. So for instance, these, does it check against arbitrary use of power or not? And third would be safeguards, economic safeguards. So, for instance, or resources safeguards. So, for instance, checking if it imposes too much burden on the regulated entities or not. Does it impose too harsh a penalty that in turn would impose too much burden on the regulated entities or not? Does it align interests? Does it align incentives in a manner that's the least cost? So things like that. So basically, once you identify these principles, our quality of laws project actually advocates for then building a checklist and then running every law through this checklist to see how it fares. So as Prashant mentioned, that one potential approach that we could adopt is for the law commission to do this check ex ante for every law, which is, I mean, ex ante review is non-existent in India pretty
Sure.
much.
So that's at one level. But the other thing is also about, when we talk about administrative law is a very departmental level practices. And so, in that sense, then we also need to have a very decentralized level of legal or regulatory hygiene in place. And if we want to ensure that all departments and all public authorities adhere to those basic minimum level of that regulatory hygiene and practices, so something similar. So for example, US has APA, India might have something similar, or otherwise at least have those public service guarantee laws in place. So I agree that India, 22 states have some sort of right to service guarantee laws, but those laws are rudimentary, and I would say that they are failures. So we need to get those laws right, We need to have some of those basic practices. Or, for example, let me give you this example of, in administrative law we often talk about due process and principles of natural justice. But what is due process and what is principle of natural justice if there is no deadline? You apply for a license and you wait forever. You never get to hear back on your application from the government department, right? So we also need to talk about promptness. I mean, I at least didn't study about promptness in the law school, in while studying administrative law. Legitimate expectation is another thing, but it is taught, but maybe not in as much detail. And if you look at judgments, etc., I mean, requirements such as promptness is not as much emphasized in our literature, in our body of administrative law. So I would say, Ms. Bagchi, that NLUs should take initiative as far as administrative law is concerned on at both levels. Be it at the level of quality of laws, institutionalizing that, reinvigorating, overhauling law commission, but also at the level of each government department and each law, and looking at right to service guarantee laws and overhauling those. And because a common man may not understand the intricacies, this is technical field. It is very difficult to make other people, a common person, understand that what is, for example, let's say proportionality, or what is legitimate expectation. But law students and the academia understands this very, very well. So it is, I think, high time that we connect the ground reality with these technicalities and push for reforms. And NLUs, as I said, can play a huge role in pushing for these reforms. And the first step in that direction would be to at least include some of this in the NLU curriculum, organize maybe symposia and conferences around this, and nudge law students to apply, some of these, for example, the quality of laws toolkit to various laws. It is practical application. Law students are competent to do this. It would also give them a good idea of where our laws stand, right? And there would be a eureka moment when law students will see for themselves that the quality of law in this country is disappointing. Yeah, and why there is the need for reform. Yeah.
Thank you so much, Mr. Narang. I'll definitely keep that in mind, and I think, of course, bridging this gap between what laws should be and how the laws are effectively functioning in the society, that remains a major concern for all of us. And I thank you on behalf of the center for sparing your time and leaving us with so many thoughts at the end of this conversation. And I'm sure the listeners have greatly benefited from this entire exercise. So, just to conclude, I would request you to, leave with certain concluding comments, and also a specific thing that you know, I think you should definitely answer, because we are looking forward to it. What has been your approach towards writing this particular paper specifically? Because thinking and contextualizing and then reducing it to a written document, that itself is a Herculean task. So how did you go about doing this, and what are your suggestions and your what would be your advice to our listeners?
So you mean advice to the listeners on how to go about research and writing?
Absolutely.
Interesting. So we can share a little bit about our story, because you mentioned what is it that prompted us to write. I think one, and this may be valuable for other researchers. One is, I think, connect to the ground. So the fact that we've been working very closely with budget private schools and private schools in general, we were very sort of intimately familiar with their woes and challenges, and realized that partly some of this has to do with you know um, how the state is as a machinery, but there is merit in also studying whether some of this is rooted in laws itself. you know um, if laws itself grant unlimited discretion and opportunities for abuse of power to the executive. So, which is why, so the prompt or the trigger for this was our interaction with and work with, stakeholders in the field, school owners in this case, also some parents, which led us to then finally look at the law to see if the cause lies there. That plus generally our interest in education governance. CCS focuses on education governance, and as we mentioned before in an earlier response, that not many think tanks are working on education governance really. So they, for instance, ASA does a learning assessment of learning outcomes. There are other institutes that look at that work with parents and things like that, or directly set up smaller sort of school-like environments to train and educate children. Very few think tanks actually work on education governance and adopt the lens that we've adopted. So, which is this discretion analysis. It also coincided with our work on the quality of laws toolkit, that we thought was again something that not many people have been thinking about. And so the two sort of coincided, which is why we thought, why not use this toolkit, this framework that we've developed for laws in general, to state school education laws that are of special interest to us as a think tank. Yeah. Anything else you want to add, Prashant? But yeah.
So I think for law students, I understand law students at times may not be able to, let's say, talk to school owners, but just looking around and observing the ground realities and then questioning the questioning what they see and going beyond the obvious to find out how it connects to the law, or if there is a or if the phenomena they observe has roots in the public policy or in the law, and then connecting the two. And yeah, so this is, we can come up with interesting topics. As far as research and writing is concerned, uh, it's basically about the choosing the right methodology is what I spoke earlier, and then putting it in writing. The one thing I think, of course, the law students learn a great deal of research and writing in the law school. One thing that I would like to add and emphasize is that if they can make their writing simpler and easier to understand, if the writing can be accessible to people who may not be familiar with technicalities of law, if there is a way to make it simpler and accessible to even other people, that would be great service, because uh, then it would reach your research, your product would reach many more people if it is simpler to read, and it can be simpler to read. uh, Although we sometimes think that complexity makes it more valuable, but that's not true. Simplicity makes research more valuable and accessible.
Just small addition to that, something that Prashant only has prompted at least your researchers here to do is sometimes it helps to look at the same hypothesis or the same research question through different methodological approaches. So that has worked in the past for us. So, for instance, even while responding to your questions, we had some insights from the law, but others from our interaction with budget private school owners. So, through our surveys. So, and then there is an economic or quantitative analysis also that we've done on state school education laws, apart from this legal analysis. So, sometimes looking at the same research question through different methodological approaches can be useful. Yeah.
Okay, again, I would like to extend my heartfelt gratitude to Mr. Narang and Ms. Bedi for this fantastic session, because specifically I believe that simplifying certain complex set of ideas, and of course writing a paper or thinking about something and reducing it to understandable piece of literature, that itself is pretty challenging. And you've given us the best of the insights, and we have learned a lot from this entire session. So once again, thank you so much for the entire session, and it was amazing. Thank you so much.